Hi everyone, I'm Suryansh, a first year at Blackstone University, and today I'm joined by Vishak Abraham, a founder and lead attorney at Venture A Law. Vishak has over 17 years of experience as a transactions lawyer. He's worked across areas like M&A and PE transactions. As a quick note, before we begin the podcast, I'd like to make a quick disclaimer. This podcast serves as an educational conversation, not as legal advice. Hi Vishak, it's really
Hi.
nice having you here.
No, thank you for having me here. Looking forward to spending time in Plaksha.
Okay. So I'd like to get the bigger picture here before we
Sure.
start on, which is why do you think, in your experience, founder agreements really matter on before we get into the specific clauses?
So it's one of those things that is uncomfortable for founders to have a conversation around.
Okay.
It is something which is also not a priority when you're actually founding a company. It's something which says, we'll deal with it later. And sometimes it doesn't get dealt with, like many things that we are uncomfortable about, right? It's not a priority. We are a little uncomfortable about it. And then you reach a place where you're raising funds, and then you have no option but to go along with the shareholders agreement that your investor is asking for.
Okay. So I think I understand the basics of why a founder agreement is so important. I think in student teams, people move quite fast, right? We go from a hackathon to a prototype, and traction ends up building really quickly. So we often end up thinking that the documentation is a distraction, and people miss it. And I feel like that's also really where people build assumptions. So my first question, which I wanted to ask is, could you, in plain language, explain what a founder prenup actually means?
Good question. And one thing which I'd like to say is that it's not so much about the contract or the law. In my experience, the founder agreement is about having a professional in the room who's a third party, a neutral third party or objective third party, who can help you guide you through some of the uncomfortable conversations that you need to have with each other, and explain what are the implications of those issues, so that it kind of guides you towards, okay, maybe we can deal with it now when we're starting off, when everything is a little bit more hunky-dory.
Hmm.
And that strength that you have right now can also hold you through those uncomfortable conversations, and maybe those uncomfortable conversations with a third party sitting in the room is easier to have, saying that it's not about distrust, because otherwise that it can be seen to be a distrust aspect to it. But because a third party is asking us these questions, we are having this conversation because we need to jot it down in some way.
Understood. So then, could you, from perhaps your experience, give me an example of what tends to go wrong when people miss these founder agreements early on?
Good. Yeah. So common things which go wrong are expectations on what happens if we decide to change course. We started the company with a particular philosophy, with a particular product or a service in mind, but maybe we need to pivot. But do both or all three want to pivot? Does two want to pivot but one doesn't want to pivot? Or what happens when there is additional capital required in the company?
Got it.
Does someone get diluted? Do you bring it in as debt? How do you bring in cash? Who gets diluted? If one person is maybe well off in a different way and is able to raise capital, now if they're bringing in either money from their own pockets or from their parents or something, is that now changing the dynamics between the three partners who are there? Or what happens if someone just decides, I want to change my job? Do I get anything or any value for what I've done till that date, or am I just supposed to leave?
Okay, so I think it's really quite important that we do work on these founder agreements from your response. Then, for students who are listening to this podcast, can you give me a few buckets on which we should align ourselves or we should base our founder agreements on?
Sure. So one of the things which is important to align is roles, roles between the founders.
Okay.
Of course, it depends on how many founders you have. How are decisions taken amongst yourselves? Now, at a later point of time, decisions might involve other stakeholders, including investors and whatnot. But this is a stage which holds good even in that stage as well. how do you take your decisions? So decision making, is there a formula for it? Is there a majority rules? Is it based on how much money was brought in? Are there veto items in there? How do you take a decision is one big bucket.
Got it.
Do you then also decide that there is a lead founder amongst us who is the one voice to the outside world? And that could not necessarily have anything to do with your designation. It could just be the charisma of the person or who you decide is the lead founder. So that there's clarity as to why that particular role is given to one of the individuals as well, right? And maybe the next two buckets is kind of related. One is your employment aspects in relation to being a founder. Because as a founder, you wear three hats. You're an owner, you are also the management, and finally, it is your intellectual / employment. You're the one actually driving the company, working day to day. There's a personal aspect to it as well. Your employment is linked to your company as well. So that and what happens in case your employment ends or you want to leave the company. So those two are kind of linked. So if you put it in those three buckets in some level, think about it, it's ownership, management, and employment.
Okay.
Maybe that's some way of thinking about it. This is as a lawyer. Of course, there are many other aspects which the business school will also tell you founders need to look at. But maybe from a legal contractual perspective, this is how I'd look at it.
Okay. So I'll just try to summarize what we just talked about, and I'll use your words for it. The aim here isn't about the legal complexity. Rather, it is about making sure that the expectations are explicit and known to everyone in the founding team early on, while everyone trusts each other.
Correct. It's the architecture that you're putting together. It's the design for the philosophy which is going to drive you to the next step. You're thinking of your exit and your investment, all of it, and having those conversations today. So that those conversations don't become difficult tomorrow. So you're putting in place a design to ensure that that design and that architecture and that foundation is solid.
So let's move on to those conversations. Exactly, right? I feel like these conversations are often really difficult for founders to have because they tend to be really awkward. And when this startup is starting, it tends to be that people feel like these conversations can feel distrustful, right? So could you help me in understanding what specifically changes when a third party gets involved in these conversations?
So I think I briefly touched upon it earlier. One thing is that it cuts through the politeness barrier. We are great friends. We've been students together. We've been colleagues somewhere else. We've come together because we respect each other's, professionalism and business acumen, whatever the case may be. But now we may not have, even if we are best friends, do we then have a conversation about what happens if you leave? The question is why do you think I'm going to leave? Do you not trust me? That's a bit of an awkward conversation to have. But the third party is there, he's neutral, he's objective, he's saying, I need to put it in the document. So he's actually not so worried about how the agreement looks ultimately, because the agreement is an agreement. It's not too complex. But his role probably there is to facilitate those conversations and make it easier. Because he's the one asking the question.
We're removing those emotions from that awkward conversation.
Correct.
Okay. So now let's say there's a startup and the founders want to have a 60-minute founder agreement meeting. So they understand what all should go there. Let's say it's a 60-minute meeting. Could you help me with what are the few minimum points that should definitely be discussed in such a meeting?
Sure. So one is, I think, what is your shareholding pattern going to look like? What is your share capital table going to look like? Regardless of what that looks like, is decisions going to go along the same lines? Or is there a different matrix that you're going to apply? Maybe shareholding, because of certain reasons, are in a particular ratio, because maybe money is involved, somebody's brought money, somebody's not brought in money, or they're only bringing in talent, whatever the case may be. But does that mean that you're valuing the talent less when it comes to decision making, because founder implies something? You're taking me on as a founder as well. So does that mean that my input is less valuable? Because then that's a conversation you need to have.
Okay.
Legally as well, because you can say that all hunky-dory, we'll always have conversations together, but where are we recording that it's a conversation that we are having, right? So that's one thing to deal with.
Okay.
And two, the other part is what happens if I cease to be a founder? That could be that I'm disabled, I die, I leave employment, my life choices change, whatever the case may be, right? What happens then?
Okay.
I think those are two buckets which need to definitely be addressed. shareholding slash decision making, and what happens if I'm no longer there.
Okay, so the student win here isn't really that perfect document. Rather, it is the fact that all the conversations are written down, and the best premise in the future isn't that, okay, we verbally agreed to this.
Yes, absolutely. The conversation, the fact that the conversation happened itself is a win.
Got it. All right. So I think next I want to bring up what is perhaps the most famous topic which gets pulled up, which is equity.
Okay.
Right. I think it's the first thing which students learn about because of shares. So let's talk about the distribution of equity. When do you think, in your experience, equal equity makes sense? And when does it end up causing troubles for the company?
So more than equal equity causing trouble, I wouldn't frame it in those words, but I think what you're also getting to is what happens when decisions can't be taken because of a deadlock in some senses. Because equity being equal will change. The minute you hire a CTO and you want to give him ESOPs, maybe the equality comes down in some senses, or maybe someone brings in more capital and the equality changes for some reason. So I would be more concerned as a lawyer, at least, about what happens in case there is a difficulty to have a decision.
Okay.
And what is the consequence of not being able to have a decision?
Okay. So then how do you exactly value this equity? How would you as a founder value this equity?
So I don't think I'm an expert, firstly, to give you too much gyan on that. What I've seen how things are usually play out is that if two people come together, unless one of them is bringing in additional capital, it is very rare that you start off with an unequal footing.
Okay.
Or it is one person's idea and that person has contacted the second person saying that I need someone who has technical skills. I've already kind of brought this idea to a particular place and we'll start the company together. But the real idea might have already been started by someone else. So those are the situations where I see an unequal aspect to it, when it is at different stages that people have come together, or at a different footing that people have come together, or if there is a monetary aspect where, money has been brought in by one and money is not brought in by the other. But there are also situations where somebody just brings in the money and the other person is just expected to bring in their expertise, and that can also be equal. Both can have 50-50 because you're valuing the contribution which is non-monetary equally as well. But again, I'm not the expert on valuing how valuation conversations have happened. Many times we're just assuming things based on what we are seeing after that conversation has happened.
Okay, so that makes a lot of sense. I think what I want to touch upon then is also about people who founders who join late. So in most student startups, we often find this person who is really smart, but they come up perhaps after the prototyping. And then the student trouble is what title should be given to them, co-founder or an early employee, or even perhaps an advisor. How do you go about deciding between those titles?
Again, I don't think there's an objective answer here. Where there might be a level of objectivity is, now how much equity are you giving them, for example. Now if that's a reasonable chunk and is close to what the existing founders have, then it might make a lot of sense to just call him a co-founder or a founder.
Got it.
Right? But if he is being brought in at a lower stake, but because his seniority and you need to attract that lady to join you, then you might be giving that designation to make it more attractive.
Okay.
On the flip side, I think the aspect to remember is that founder versus KMP actually does have a material difference when it comes to, say, fundraising.
Okay.
When you take on the designation of founder or co-founder, there's likely to be an expectation of liability as well. So the co-founder or the founder many times might necessarily have to take on certain liabilities like indemnities and representations to your investors. So there's an aspect of that which they may not have considered as well. It's not just the designation or the title. There is also an aspect of liability which comes along with it.
Okay.
I've in fact doing something recently where a co-founder was brought in at a slightly later stage who was a industry expert. On the flip side, I had a conversation with the founder saying that, are you sure you want to call him a founder / co-founder? He said, no, I don't want to call him a co-founder, I want to call him founder. I said, okay, but we are raising capital. There might be implications. Have you explained those implications to the founder as well? I mean, to this gentleman as well. He said, no, he's senior to me. I need to have him.
Okay.
And, we need to give him that kind of respect. I was like, not my call, completely understand, but this is what it'll probably mean. And so when the investor comes, their expectation is very clear. He's going to have the same obligations as the other founders who hold a significantly more larger chunk in the shareholding, and the same liabilities, which means that he's giving indemnities, taking on some level of personal liabilities, things like that.
So I feel like that also solves to an extent the problem of how do you make it fair and equal for the founders who started from ground zero. For a person who is joining late, if they're getting that title of founder, then they also have to sacrifice, I'll say, as much as us early on founders.
Absolutely, because what you're offering is not just the skin in the game from an upside, but it's also not just the equity downside, but it's the reality of the founder's downside, which is where you're standing behind the company and what it does, not just the mathematical equation of what the equity downside could be.
Okay, all right, that makes sense. So when I look at startups, specifically student startups,
Sure.
I feel like a lot of them start with two people, where one's the person who's great at networking and the other is the person who's great at building. But I feel like this two-person team also means like it's quite easy to get stuck. So I remember you mentioned deadlock earlier, and that's the topic I'd like to get at. Both people can be very smart and they can be well intentioned for the company. However, we often end up in situations where the two founders might have a 50-50 or one might have a veto and they disagree on a major decision. What do you think are practical deadlock breakers there?
Sure. To keep the conversation simple, we'll take the two founder scenario.
All right.
Because once it increases, then the levels of complexity might become more problematic. So typically when there are two founders and they're both equal in shareholding, what typically happens is that if there is a deadlock, you try and put in place things which will be in the form of, say, a mediation or a conversation, maybe involve a third party who's, someone who's well known in the industry or who they both trust to maybe resolve that before it goes into some kind of deadlock resolution, which is more where you leave or I leave.
Okay.
Because ultimately that's where it is, right? And also, when do you declare that deadlock? Is it just because I said no to one thing? Shouldn't be. It should be where there are multiple instances of it happening and the business of the company is now being affected, right? So there are a couple of things which I've seen how that gets resolved. One is, of course, a clear one, both people put in a number in some senses to buy each other out, and whichever number is higher gets to buy the other one out. That's a very simple, and that shouldn't be the exit shouldn't be the end result of it, ideally. But sometimes there's no other option when it's just two people and their shareholding is equal. If there are two people and the deadlock is arisen because of a veto and there's one person who holds higher stake and the other person holds a lesser stake, then there might be a potential for a resolution which doesn't involve, selling the company. It might be saying that, okay, after so many rounds of negotiation or mediation, then we'll have to go with the senior shareholder's decision. But the junior shareholder can now leave his employment because now he doesn't want to, without any consequences. He can keep his shares and take the upside whenever the company grows.
Okay.
That might be one way of dealing with it, right? You're just saying, we're parting ways. I'm not, you should get to keep, deciding what you want because you are the senior shareholder. And that's what we've agreed in the framework that we've agreed to. But I've not done anything wrong either, so I'm not losing my shares.
Got it. So both of them are benefiting in
some
way.
senses.
All right.
But this again, when we say deadlock, it's actually when we are deciding to part ways in some senses.
Okay.
As founders. Not necessarily as shareholders, but as founders.
Okay, I see. So I understand deadlocks seem to be quite a bad thing for any startup. Could you suggest from your experience as a lawyer, what are some lightweight governance which startups can do in order to avoid these deadlocks in the first place?
Very good question. I think that's the most important question to ask. How do I ensure that these deadlocks don't happen, rather, right? So, putting in place clear vision, a business plan, a detailed business plan with an outlook. We want to ensure that XYZ can happen within so many years. If we can raise capital up to this much, we can not raise capital up to this much. If company needs more money, we first take debt, so on and so on. I mean, just giving random illustrations, but it could be anything which is more documented. And then if you want to revise it, both parties need to come together again to revise it. So at least the founding principles are laid down in some kind of structure. Doesn't have to be a formal business plan, doesn't have to be a formal budget, but it's recorded that this is what we are trying to adhere to.
Okay.
So this is the pathway. Now, if you want to deviate from the pathway, that is when someone should be able to say no. If we are going along the pathway, then neither party should be able to prevent the path of the company in that direction.
So would you say this is another one of those points which definitely should be there for founder agreements early on?
I think that it may not necessarily be. It depends on shareholding structure.
Okay.
If the shareholding is absolutely 50-50, I would say maybe, because chances of deadlock resulting in one of those you go your own way becomes far more problematic. If you can put in place at least a conversation starter in terms of where the direction of the company is, that's always a good idea as well.
Okay, all right. So the next topic I'd like to bring is, then you're mentioning founders end up moving in different ways or like different paths. So I feel like another reason why this happens is when a company decides to pivot. Students often join a startup for a specific mission, and it's not necessary that the company sticks to that mission. Companies often end up pivoting for their own gain, and then founders end up feeling like, I didn't sign up for this. So how do you protect a founder in this case if the company decides to change their course?
So that actually ties in with one of the earlier points that we discussed, right? In the sense that you're setting out a pathway and then someone wants to deviate away from it. So when it is 50-50, it's usually sacrosanct that you can't move away from that pathway. But let's assume that it's not 50-50. There are 3 founders. 2 of them want to pivot. 1 of them doesn't want to pivot. Should you penalize the guy who doesn't want to pivot because he's not doing anything wrong? He's continuing the course which was exactly agreed to by all 3 of you, right? And that's why he's there. So in many cases, the resolution is, yes, you do go along with the 2 because that's where the majority wants to go. But you can't penalize the 3rd. If he now wants to resign as a director, resign from management, but still keep his equity, that's still a fair resolution for him. So when we talk about leaving, we have these concepts of good leaver and bad leaver.
Okay.
Good leavers are people who have not done anything wrong, in a very simplistic layman's term. Whereas bad leaver is someone who's done something bad to the company and therefore they're being forced to leave. So in this situation where the guy doesn't want to go along, he shouldn't be seen as someone who's protesting. He is, but his protest is to stay the course, which is what the mission that you were mentioning. So he should still be considered a good leaver. That's one way of resolving it, or maybe trying to ensure that he's not completely taken out of the picture. But the majority going one way should always be given respect to also.
Got it. So then, let's say there's a founder. He strongly disagrees, right? What are some expectations that should be set in a startup about pivots or decision making beforehand to avoid this problem of, is this founder going to become a bad leaver or a good leaver?
Literally what we spoke about. So when you're tying in your employment agreement, your equity reverse vesting or your ESOP, I mean, founders typically might find it difficult to have ESOPs because of certain Companies Act restrictions, but basically reward structures which you have in place. So you tie it in with that. In what is the situation in which the person has resigned, for example.
Okay.
So you say resigning for good reasons, and what are those good reasons is something which you'll have to elaborate on.
Understood. You use the term reverse vesting.
Sure.
Could you in plain English try to explain what reverse vesting is?
Sure. So unlike in ESOPs, where you get new shares once it vests. So you have a vesting period. Say over 4 years you will get 10 shares, assume. Every year you get 2.5 shares, so on and so forth. I'm just making up some number, but in reverse vesting, the concept is that you've already gotten your shares, but the assumption is that we are equally divided. Assume that you and me start a company and we have 50-50 shares. But the assumption is that both of us are running the company for X number of years at least together.
Correct.
Because if you're leaving in between, I need to bring someone else in. So reverse vesting ensures that you are earning your right every year to keep the security rather than get the security. So that's why it's reverse in that sense.
Understood. But I hear that in reverse vesting there's often that cliff conceptually. Could you explain why that exists or where that exists?
Sure. So the reverse vesting can be in two situations or multiple situations, but in two scenarios in some senses. One is vis-a-vis just the investor, just the shareholders, the founders. Say, for example, I started the company and I hire you as a CTO.
Okay.
And I give you, say, 30% of the shares or even 50% of the shares. But you have not put any money into the company. I need you to continue being the CTO for the next 4 years, and then only I'm saying that you have earned your keep. Because I have put in money into the company, started the company. So I'm kind of putting that on you to continue being there. So the cliff is where you're saying that I'm bringing more value than zero on day one. So I say, okay, fine. So it's not 100% of your shares which get reverse vested, but say 80% of the shares. So in some senses, not cliff, that's not the cliff, but that's the first period of time where I'm saying this doesn't even apply to your reverse vesting. Okay. The cliff is the period where initially, say for the first 1 year, I'm saying you don't get any vesting.
Okay.
So if there's a cliff of 1 year, it means that for that first 1 year, you first earn out that much. Then after that, every month or every quarter, you earn X number of shares and that those get released.
So would it be correct to say that this reverse vesting is protecting all the founders together because it ensures that it doesn't happen so that in, let's say, in a year, one founder leaves and they still get the equal amount of equity as the other founders?
Correct. That's basically what it means.
Okay, all right.
When it's only amongst the founders, because reverse vesting happens, that's a scenario 2, when the investor makes you reverse vest. The investor is now paying you a lot more money and giving the company a lot more valuation than what you guys have actually put into the company. So then the same logic applies, but vis-a-vis the investor.
Okay. So I feel like when we talk about equality and all in startups, there is one problem which often ends up coming, which is IPs, right? Students begin from their own projects, their personal passion, GitHub, hackathons, and suddenly in a startup, a question can arise of who exactly is owning this? So what are the most common IP mistakes do you think exist in a startup in the first 6 months?
So the easy one to answer in some senses, I mean, there are many different ways, but the very common ones are, say, moonlighting. Someone is actually working in, say, Amazon, but trying to start his company Y, so he's creating codes for company Y while sitting in Amazon or wherever, I'm just saying randomly making, company Z. There's a good chance that his employment agreement talks about who that IP belongs to because he's creating it during the time that he's in employment with company X or company Y rather. And company X, when you're actually going to create your IP, do you really have full title to that IP? Will be a question which might arise.
Okay. So, sorry.
No, say other instances are in some similar line. You've started a company, you've started building a product informally. But there's no formal architecture or agreement between us. And then when the company starts, you've forgotten about assigning those rights which you had as individuals into the company. And 4 years down the line, you've still not done that. That becomes a problem if you're not realized that the actual codes that you created or the trademarks or the brand or the whatever that you've created, the IP that you've created is sitting actually in your names.
Okay. So what do you think is one thing that we should definitely avoid or like take care of in IPs when a startup hires, let's say, an intern or a contractor specifically? Because I think I now understand what to do when I'm starting out early as a founder for these IPs, but I feel a bit like there's an ambiguity for what to do regarding these IPs when I'm hiring a contractor as a startup or, as a matter of fact, an intern.
One maybe is some level of due diligence to understand, is that person already working somewhere else? Has he finished his employment agreement there? Is he bound by any kind of restrictive IP provisions under some existing agreement? And 2 is entering into some form of agreement, even if it's a one-pager, saying that from now on, everything that you create is work for hire, which means that I'm hiring you to do this, so whatever you create belongs to the company.
Okay. So I think the next topic which I'd like to get to is about founder employment agreements, right? I feel like the founder employment agreement really is like one of those terms which sounds like, oh, this belongs to a really big corporation or a company, not to your startup. But at the same time, it has that really important value which all startups should take care of. So why do you think that these founder employment agreements really matter for founders?
Two reasons. One is to set a precedent before you actually do fundraise, saying that we have a robust founder agreements in place, which has IP assignment, which has definitions of what is cause, what is not cause for termination, what is good reason. Those are already structured and put in place, and there's good hygiene. So when you're actually going for fundraising, it shows excellent hygiene at your end.
Okay.
And two, if you do have some form of reverse vesting, it doesn't work without a founder employment agreement.
Okay.
Because it talks about how you're terminated from your employment, leading to whether it is vested, not vested, whether you're a good leaver, bad leaver. So the most important thing is the definition of what is cause for termination. That's probably the most important point to look at.
Okay, so you mentioned the cause of as an important point. What do you think are some other minimum points which should definitely be there in a founder employment agreement?
Sure. More than what should be there, I would say what shouldn't be there. Shouldn't we have trivial provisions which are there for typical employment agreement provisions, where you're normal run-of-the-mill employee, where you have things like, you should attend from 9 to 5. If you don't attend from 9 to 5, it may not be considered, things which are too specific, which can lead to reasons for non-compliance and then therefore reasons to terminate, shouldn't be applicable for a founder.
Okay.
It should be, you should accept the fact that this is his lifeblood. This is what he's doing from day morning to evening. You can capture that in some form. So the two important things which necessarily should be there, if at all, is what is the definition of cause? It has to be a very specific, objective definition. And two, there has to be IP assigned into the company.
Okay. So I think that really helps me understand a lot about the legal relationships which are there in founder agreements, and specifically now the founder employment agreements. But to make this podcast a bit more actionable, right, to just before we finish, I'd like to ask if the Plakshans here, if the Plaksha students had to take away one thing from this podcast, what do you think that should be?
It's the first thing that you ask me. Have that uncomfortable conversation. Have that as soon as possible before you actually start your company. Figure out amongst yourselves what are the roles that you're playing, what different roles that you're playing. What happens in case this doesn't work out? How do we split ways and go our different ways?
Okay.
That's the conversation to start with.
All right. So thank you so much for your time, Vishak. It has been great having you here.
I hope I was able to add some value. I know I went all over the place like most lawyers do, but I wasn't prepared well enough. Sorry.
No, it was great. This was a great conversation to have. Thank you so much.
Thank you so much as well.